Yep. Started recording and then the live on YouTube. That's what I just did. And
Okay, here we go. So my name is Brad Blanchette. I am the chairman of the Zoning Board of Appeals. And this open meeting of the Northborough Zoning Board is being conducted remotely, consistent with Governor Baker's executive order of March 12th, 2020, due to the current state of emergency in the Commonwealth due to the outbreak of the COVID-19 virus. In order to mitigate the transmission of the COVID-19 virus, the town of Northborough has been advised and directed by the Commonwealth to suspend public gatherings, and as such, the governor's order suspends the requirement of the open meeting law to have all meetings in a publicly accessible physical location. All members of the Zoning Board of Appeals are allowed and encouraged to participate remotely. The order allows the Zoning Board of Appeals to meet entirely remotely so long as reasonable public access is afforded so that the public can follow along with the deliberations of the meeting. The public is encouraged to follow along with the using the posted agenda unless the chair notes otherwise. Members of the public who wish to view the live stream of this meeting may do so by going to Northborough Remote Meetings on YouTube via the link listed on the agenda. Ensuring public access does not ensure public participation unless such participation is required by law. This meeting will feature public comment. So tonight is Tuesday, July 28th, and the Northborough Zoning Board of Appeals meeting will come to order. And in accordance with the provisions of MGL Chapter 48, Section 9 of the Zoning Board of Appeals, hold a public hearing on Tuesday, July 28th, 2020 at 6 o'clock to consider the following hearing. So I already went through Governor Baker's provisions. So to start off, we're going to go with the continuation of the consideration of the petition of the New Bridge Granite Corporation for a variance special permit with site plan approval / special permit groundwater protection overlay district to allow the finishing of marble and granite countertops and related items to be in a showroom to display and sell on the property located at 329 West Main Street in the Business West District and Groundwater Protection Overlay District 3. So we, Kathy, I know we just got an email earlier today, so they are asking for a continuation to our August 25th meeting.
Yes.
My 5 looks terrible.
Yep. The email came in from the attorney representing New Bridge Granite Corp. Asking that it be continued to the August meeting. They're still waiting for their site plan to be finished. So you just need to take a vote on that, Brad, to a specific date and time. And you also need to do, every vote that you take, you have to do by roll call.
Okay. Noted.
Mr. Chair,
Yes.
I move that we continue the special permit site plan approval application for 329 West Main Street to our August 25th, 2020 meeting at 6 p.m.
Second.
Okay. Fran made a motion to move the 329 petition, New Bridge Granite Corp. to August 25th. Mark Rattan seconded.
We just need a specific, Brad, you have to mention the time at 6 o'clock.
Oh, 6 o'clock. Got it. At August 25th, Tuesday, August 25th at 6 p.m. Eastern time. So Fran Baxtron made the motion. Mark Rutan seconded the motion. And we'll do a roll call, but all those in favor?
Fran, I.
Dick Rand, aye.
And
Paul Tagliaferri.
Mark Rutan, sorry, Paul. Mark Rutan, aye.
Paul?
Yep, Paul Tagliaferri, aye.
Okay, Brad Blanchett as well. Okay. So unanimous decision. The New Bridge Granite Corporation application will be moved to Tuesday, August 25th at 6 p.m. Eastern. All right. Good, Kathy?
Yes, yep,
Okay.
thank you.
All right. Yep, no problem. Excuse me. So moving on to the second piece of the agenda, a continuation of the consideration of the petition of Berlin Landing Realty Trust for an appeal to build a daycare center with an associated parking lot, which will be leased to an appropriately licensed nonprofit entity on the property located at 5 Barefoot Road, map 30, parcel 33, in the industrial district and the residential C district. I don't have the name. I know it was a continuation, Kathy, and
Yep.
we met with them last month. I don't have their name.
That's okay. You, for the people, the applicants, Brad, are Scott Goddard is the applicant, and being represented by Fletcher Tilton, and at last month it was Mark Donahue, who is not available this evening, but one of his counterparts at Fletcher Tilton, attorney Nisha Koshi. And Nisha, I'm sorry if I said your first or last name incorrectly, but we haven't spoken, but we've been emailing. So they are both, I think I did see them both in the attendees.
Okay.
Yes.
David, would you mind moving them over
They're coming
and
in now.
letting them present?
Yep.
Mr.
Scott Goddard's been let in. How you doing?
Scott Goddard, Mr. and Mrs. Koshi.
Hi, this is Nisha Koshi from Fletcher Tilton. As Kathy mentioned, I am filling in today for Mark Donahue. It's a pleasure to meet everybody.
And Brad, I just want to point out before you turn it over to Nisha and Scott, that you have, there was two additional pieces of, well, two letters that came in for the file, and they were sent to you. There's one from Mark Donahue, which is dated July 21st.
Mhm.
That's a 3-pager that everyone should have. And if you don't, I will try to get it to you as I'm sitting here. And then there is also a second letter from Mary Bassett, attorney Mary Bassett. And that is a 3-page letter that everyone should have with a map attached to it.
Yes, I can speak for myself. I received both, so thank you. So have all the members of the board received these letters, reviewed them?
Yes.
Okay. Okay. All right. Thank you very much. So Ms. Koshi and Mr. Goddard, you may proceed with any updates based on last month's discussion regarding 5 Barefoot Road and the daycare center.
Thank you. I'd first like to mention, and it was in my letter, that when we originally filed the application, it was intended that the daycare center as proposed would be leased to a nonprofit. The likelihood is that it will be an actual for-profit entity maintaining the other requirements of the statute. The statute specifically provides, as I said in my letter, that a child care facility that is exempt from zoning per the Dover Amendment can be a for-profit or nonprofit. It does not exclude for-profit childcare facilities. So I think that's an important thing that as we move to the next stage, that it be clear that this is not specifically for a nonprofit childcare center. So I know that was one of the issues when I spoke to Attorney Donahue that was raised at the last hearing. So if there are questions about that, I'm happy to address it, but based on my reading of the statute as to how childcare facilities are defined within the Dover Amendment, it's irrelevant whether it is for profit or not. Okay, so if there's no questions on that, my understanding that the second issue relates to how the setback requirement interplays with the Dover Amendment. And it's our contention that while the 100-foot setback requirement may on its face be facially reasonable, and we're not going to dispute that because that's not our issue. The issue for the analysis of the Dover Amendment is when you apply it to the specific facts of our project, does it then become unreasonable? Because the Dover Amendment has these specific protections for, in our case, a proposed childcare facility. And while the town is still permitted to apply reasonable zoning regulations as they apply to setbacks to the project, it's our contention that if we are to comply with the wetland requirements and we've already been approved with an order of conditions by the DEP and the 100-foot setback, essentially we cannot build on this property. And contrary to what was, I believe, stated in Attorney Bassett's letter, it's not that we're looking for a blanket exemption from all zoning. We're asking for an exemption to the 100-foot requirement. And why is that? Because if you apply that with the wetlands buffer, then there's only a very small portion of the property that can be built upon. And we're not saying that that applies to all the zoning requirements, but specifically to the 100-foot setback requirement. And why we think that is also unreasonable is because Northborough permits childcare facilities as of right in residential districts. So while we understand that the town is trying to create a buffer between an industrial zone and a residential zone, in this case, where the town allows daycare facilities in the general residential district, then it doesn't make sense that it would preclude it simply because you're trying to create that buffer, where the buffer doesn't necessarily exist itself in the residential district. So for instance, Mr. Donovan, I think it was, submitted a list of daycare centers that are in the area. And when I looked them up on the assessor's office, I believe at least 3 of them are located in the residential zone. And so they're not being subject to this 100-foot setback requirement. Additionally, and Scott can go into further detail about this, the location of where the facility would be is across the street from Pondview, the closest residential location is, I believe, at least 100 foot away. So the buffer is there by virtue of that street. So for those reasons, we don't think that in applying this rule, which is reasonable, for the sake of argument, to our particular parcel, it then becomes unreasonable and we're entitled to the Dover protection as a result. And in fact, in the table of uses at section 7.05.030 of the bylaws, at the very top says exempt uses are allowed as of right in the RA, RB, RC zones. And included within those exempt uses is daycare facilities under Chapter 48, Section 3. So hopefully that explains why in application, this rule is not reasonable to our project.
Okay. All right. Thank you very much.
You're welcome.
And so before I open up to questions to the board, are there anything else you'd like to address or, sorry, I got a bunch of things going here.
Mr. Chairman, if it would be helpful, I could also
Yes.
screen share and this is Scott Goddard. I could screen share.
Mr. Goddard,
put up
thank
a
you.
map if it's helpful for discussion purposes like we did last time.
Sure.
I'll leave that up to your discretion.
Yeah. I mean, the floor is yours right now. So feel free to.
So
Bring
can
that
you
up.
all see
Is everyone able to see this?
that screen I just posted up? So that is I think that was the most useful map rather than get into the details of engineering, which are of course subject to site plan review with the planning board, which would be the next step after the zoning board in this case. This map, I think, does a nice job at simply showing what we're requesting. As a quick recap, the red line that outlines the property is the property line. It does meet the area and frontage requirement of a lot in this industrial zone. So we meet those requirements. The hatched in blue area is the wetlands. Those red and pink lines offsetting the wetlands are buffer zones required under Northborough's Wetlands Protection Bylaw. As a reminder, we do have an order of conditions from the Northborough Conservation Commission approving this project. The yellow line that parallels the rear lot line is the 100-foot zoning setback from the residential to the industrial zone. I assume you can see my cursor. That's this line that I'm outlining right here and all. So a strict application of that regulation, which is the one we're seeking this application of the Dover Amendment on, would put the building in an area that is wetlands, as you can see. So that wouldn't work. This is the usable piece of the property where the building is currently proposed. Now, we're not suggesting no setbacks. We're applying the 20-foot setback to the property line, which is where it would be if we were in a residential zone. Furthermore, we show these leader lines, 326 feet to the west, to the nearest residential property from the proposed building, and south 164 feet to the units on Pondview Way, to show that in practice, we do in fact have more than 100-foot setback. So the substance of the intent of that regulation, I believe, is satisfied. So I'll leave this map up for further discussion and comment with the board, unless you'd like to see the site plan review. I can bring those up, specific site plans, excuse me. In addition, we have water, sewer, gas, all at the street. So the lot is set up and prepped for appropriate development as proposed.
Okay. All right. Thank you. So before I open it up to questions to the board, would you mind summarizing why you think the Dover Amendment supersedes what our zoning bylaws are stating, why this is not a buildable lot based on our current bylaws and abutting residential neighborhood?
I think it'd be best if Nisha took that one.
So we're not saying that the Dover Amendment supersedes any of the bylaws. Again, the town can enact whatever reasonable bylaws it requires to protect its various neighborhoods. And in this instance, the town incorporated a 100-foot setback requirement. And as Scott mentioned, we comply with everything but that. So when you have that instance, what the Dover Amendment requires is an analysis of not why is that particular bylaw unreasonable on its face, because that's not what we're arguing. It's only as it applies to this project. So as Scott said, with the wetlands conservation area buffer, and if you then add the 100-foot buffer to this, the area of land where this can be built, it makes it unfeasible to do so. Whereas if you minimize the setback, the 100-foot setback, as it is in residential zones where daycare facilities are existing and allowed as of right, then we will be able to build on the lot. There will still be a buffer between the residential zone and the industrial zone. So we're not asking for this bylaw to be superseded in any way, just as it applies to this particular project and this particular parcel, it's unreasonable as it renders the property for this particular use unusable. And where they're allowed as of right, and where the bylaws expressly state, if you have an exempt use under 40A Section 3, which we have, because it's a childcare facility, then you are allowed as of right in that district, in the residential district, and they don't require the same setback requirements as is required in the industrial zone.
Okay.
So for instance, in the case that I cited, Rogers versus the town of Norfolk, the court held, and it's a different town in that, as the court stated in that opinion, Norfolk is a 95% residential town, which I think is very different than how the makeup of Northborough. And it found that the requirements on the dimensional requirement for this daycare facility was reasonable on its face, but then when it was applied to the actual property, it wasn't reasonable because it basically rendered it impossible for them to build the childcare facility on that lot, which is the same as in our case. And it also rendered the use of an exempt use impossible. So there's an additional protection per the Dover Amendment for exempt uses. Not all uses get this Dover Amendment protection. It's very clearly enunciated in 48 Section 3, what is protected, what isn't. So that in a nutshell is why, it's not that we're seeking to expel that bylaw or see it be not applied to all other cases, but in this particular instance, it's not reasonable in application.
Okay. All right. Thank you. And again, before I open it up, Mr. Federico, our building inspector, do you have anything to add or incorporate into this discussion before we open it up to staff, board members?
I really don't. The situation has not changed. What they're looking for is a waiver of the 100-foot required setback. Although the use of the building is fine, excuse me, and the conservation has approved it, the conservation has nothing to do with zoning and setbacks. This is purely a zoning setback requirement. Again, the reasonableness is the argument that's here tonight. The question is up to the ZBA to determine whether or not that is reasonable. That's about all I have.
Okay. All right. Thank you. All right. Now we're going to open up to the board. Do we have any questions? Let's see if I can open so I can see everyone.
Hi, Fran.
Fran, thank you.
Okay.
Just raise your hand, just yell out.
Well, first I had to find the unmute button.
Yeah, I know.
Okay.
I am trying to find everyone's images.
All right, so I'm just trying to wrap my head around this, and so if I understand it correctly, if in the industrial area, let's say somebody came and said they wanted to open, I think it's a bus station, a bus stop. It's allowed by special permit by the planning board. They would have to adhere to the 100-foot setback if they want to do that bus stop. Is that correct? I guess that would be a Bob question.
If the bus station was abutting, if the property
This
abuts,
property.
if the property abuts a residential zoning district, then yes, you are required to maintain the setback.
Okay, all right. So the idea that they're saying the use of this proposed building would not be as offensive to the residents because it's a daycare that is normally allowed, which a bus stop would not be. It counters the reasonableness of the setback. And I guess that's for the applicant. Is that the argument or that's your position?
I think, yes, the one thing I'd add to it is it's not the reasonableness of the bylaw, the setback, it's in itself, it's the application of that to us,
Yeah,
taking
yeah.
all of those. So yeah, that's the bottom line.
Okay, and in the industrial area, we do allow by special permit of the planning board, educational use. And that's the hook with the Dover Amendment, because that makes a childcare is considered within educational use because of the Dover Amendment, right? So I'm connecting the dots correctly?
Well, the Dover Amendment specifically calls out the exemptions in Chapter 3,
Mhm,
which is educational and daycare
mhm.
and religious, okay?
Yep.
One thing that you have to realize is that the Dover Amendment has, in my opinion, two things to worry about. One is the use. And I, as a zoning enforcement officer, the use of the property, I don't have a problem with. I think it fits all the models and requirements of the Dover Amendment. The Dover Amendment, the project would have to come under reasonable regulations for setbacks and all the other things that are listed in the requirements. When you talk about reasonable, I think it's a matter of degree. My interpretation is that, reasonable, this thing was designed, vetted, and brought to a town meeting, and the townsfolk of Northborough approved this. And, I would consider that reasonable. I do know that the ZBA has granted variances in the past, but each situation is different, and it's not really fair to compare one situation to another. I think each situation has to be taken on its own merits.
Right, but just for clarification, this is not a variance. This is an appeal of an interpretation of
Right,
reasonableness,
right.
right? Interesting.
Right.
Correct.
Okay. All right.
Mhm.
Okay. Food for thought. Thank you.
I would think at the end of the day, it might be a matter of semantics. Because if you, at the end of the day, if you look at it, if you were to say that, the 100-foot setback is unreasonable, at the end of the day, they would have their 20-foot setback. And, does it carry the same weight as a variance? But I think the effect is there that it is the same.
Thank you, Ms. Baxter and Mr. Federico. Any other questions from the board? All right.
I have a question now.
Oh, there you go, Dick. Thank you.
What is going to be the final square footage of this building when you're through? At the last meeting, you said it was going to be a 3,000 square foot footprint, but you didn't specify how many floors there were going to be above that footprint. Can you?
It's 2 stories.
Definitely 2 stories?
Yes. And let me see if I have Can you see this map that I just posted?
I can.
So this shows kind of an initial concept of what it would look like if it were 1 story with like a half second story. But so this is an initial kind of concept of what it would look like. So to your point, you know, could it be less than 2 stories? It could be a partial second story. The exact architectural design is still kind of a work in progress, but I would expect that it would be somewhere between a 1 to 2 story. It certainly would not be more than a 2-story building, but different iterations are being contemplated at this time.
Okay. I have a question.
Oh, go ahead,
You
Bob.
plan on leasing this
Oh,
as,
Dick. Sorry, Dick. Go ahead, Bob. I hear you. I see you
Okay, thank you.
afterwards. But Dick. No, sorry, Bob. Dick, go ahead. Sorry.
my question is, if you're planning on leasing this and you're gonna have a
Virtual
lease
meetings.
before you get a building permit, what happens if that lease expires and you can't find another child daycare center to go in there?
You know, this property is being, you know, that would be the same problem you would have if you were to build a church in a residential zone, right? So that you would be looking for another use potentially that would fit within that Dover Amendment, right? Otherwise, you would have a problem.
So how would we resolve the problem if it came up? Would you tear the building down?
Well, you know, those are the same problems that are faced with other daycare centers and other church buildings, right? I mean, the goal is to not have that situation occur. The goal isn't to build a building to not have it be occupied. So I think the business plan, you know, consists of having an occupied space there.
And I
And,
think
yeah.
it would be, sorry, I think
go
it
ahead.
would be difficult to know what would happen if a daycare center for whatever reason became non-functioning there, just because there may be several changes in circumstances. I understand there are changes being proposed to the bylaws. So I think that's, you know, as Scott said, we'd keep it within the Dover Amendment protections, but I think that's a difficult question since we don't know what will be presented in the future with regard to zoning bylaws and changes.
Okay, thank you.
So you're saying you don't have a tenant lined up. You're just saying we're going to build the daycare, but it may be a religious occupation. Is that what you're saying?
Right now, the plan is to build this as a daycare. There's no plans to make it a religious institution. But I think the question by Mr. Rand was, could there be a plan B, for example, if a daycare center will ceased to operate there at some future date? And I think that, you know, could it be possible that, for example, a church could take over use of the building, you know, and I think that would be probably, I don't want to answer for the board, but I think that probably that could be under the Dover Amendment as well. So, but it would have to fit within that context, you know, at a future use.
Okay. All right. Thank you. Mr. Federico, you had your hand raised a few minutes ago. What would you?
Yes, I did. Thank you. The applicant made mention of a story or a story and a half building. You know, if it's a single story and you've got your parking designation correct, that's one thing. If you go into another level of occupancy in this building, you're looking at a couple of things. You're looking at a sprinkler system and you're also looking at increased parking requirements. The other question I have is, and this is more of a technical issue, you know, you've got wetlands within 20 or 30 feet. If you decide to do something where there's a basement involved, how are you going to get, how are you going to avoid hitting groundwater?
So I think, Mr. Federico, these are great questions and appropriate. Are those questions part of this process, or is that more suited to a planning board site plan review discussion?
Well, it's certainly going to be part of a planning board site plan review.
Mm-hmm. Right. So I think that maybe it's best to table those questions, which are good ones, to the site plan review: parking, building design, groundwater elevations, et cetera. I think all those can be satisfied to the planning board for sure.
Okay,
But we have to get past this step here in order to get to the planning board.
okay.
Mr. Chair, for
Yes.
Fran, for clarification, I just want to check because Mr. Rand just asked about it last month. It was about 3,000 square feet. I had written 3,500. But when I look at the picture, it says 48.8 width by 96 length. That's 4,600 square foot footing for just a single level. So I guess just want to make sure it is fitting in the spot that it is indicated.
So,
Yeah, Mr. Goddard, can you please reply?
sure. Let's see.
That's not even including the wing.
So that's the actual proposed building right there. 3576 with a slab elevation of 238.25.
So that's 34 plus 14 if you're looking at the little 14 by 32 arch.
Yep.
Right, so that's 34 plus 14 times 92.
Right. So
92,
take 34 feet times it by 92 for the big piece here.
right.
And then you can add a 32 by 14 piece here. And that will give you 3576 in total.
So the drawing is more of a, well, that's 3128. Yes, so it's about 3,500 square feet.
Yep.
Which is different than the drawing, which we were using as reference.
And it does state, Mr. Federico, a slab elevation here, as opposed to a basement dealing with groundwater issues.
And
Very,
then,
very sandy soils out there as well.
So no basement.
Correct.
Okay.
okay, Mr. Chair, just one follow-up. This was
Sure.
just a follow-up because a lot happens in a month in the COVID-19 era. Are you still comfortable with believing that a daycare that is laid out in a 3,100 or 3,500 square foot building would be doable and successful?
So I mean, that's a fair question. And there's, the short and long-term planning with respect to COVID. So this is more of a long-term, plan with this project. So with the hope and the expectation is that the times that we're within is short-lived and not, long-lived. So that's where we're at on this. I think that the need for daycare will continue, and we'll have to figure out ways to operate. If it's a reduction in number of kids, whatever ends up happening from a government and regulatory perspective, then so be it. But the limitations of this building will be what it is.
All right, thank you.
Sorry, write down notes. Thank you very much. Any other questions from the board? Paul?
So just to follow up on Fran's point about the structure, so it does look like, it does look like the property that's on the screen right now is different than this one in color that we have here.
Yeah, the one in color is simply just that's not a official submittal that's saying we're going to build this. This was just kind of showing what could generally fit there. That's not a design plan that's being submitted for a building permit or any such thing. That was a very early on concept plan. The one that's before you that I have displayed right now is what fits there from an engineering perspective, and any future design constraints will be limited to this 3,576 square foot footprint.
Okay, thank you. And then, Mr. Chair, just one last question.
Sure.
The edge of the building is how far away from the wetlands? If the applicant could just confirm that.
Yeah, so there's a 30-foot no structure buffer zone that's applied to this project, which was approved by the Conservation Commission. So the nearest points of the structure is 30 feet to wetlands.
Thank you.
Anything else, Paul?
No.
All right. Any other questions or comments from the board?
I'm also looking at that diagram, Mr. Chairman.
Yeah. Go ahead,
Um,
Mark.
and there's a proposed fence on the east side.
Yes.
How far is that from the building?
So it varies in width. At some points, it's narrowed down to about 8 feet in order to allow passage, and at other points it bumps out further to allow usage. So, but at the narrowest point, it's wide enough for, pedestrian access.
Okay. Oh, so it's not the dashed line, it's the line of blocks?
Correct.
Okay, thank you.
Okay. Thank you, Mark. Anyone else?
The dash line, for clarification, is the no structure setback from conservation.
Okay, thank you, Mr. Goddard. Yes, Paul. Yep, I can hear you. I see you, Fred, but I'm gonna go to Paul first, and I'll get you after.
Sorry, just Mr. Chair, one clarification. So
Sure.
the fence line, which is the squares with the lines
Yes,
outside of the no structure or inside of the no structure.
correct.
Okay.
That's not considered a structure per conservation.
Okay, thank you very much. That's all.
Okay, Mr. Litchfield? Fred, you're muted. By the time we get used to all this stuff, and then we'll be back in the same room together. So that's the way it's gonna be.
Possibly. Can you hear me now?
Yes.
All right. If the applicant could zoom out a little bit from the plan that's on the screen, you can see there's a retaining wall shown along the property line that appears to be in excess of,
Hold on. Sorry, hold on, Fred. Mr. Goddard, would you mind zooming out a little bit, please?
Yeah.
Per Fred's request.
Yeah, let me open this up a little bit.
Is that good, Fred?
yes. And,
Okay.
and I'm curious that if the plan were approved as submitted, or the concept of the Dover Amendment, would that retaining wall that's 5.5 feet tall of exposed wall, would that require a variance? And if so, is it appropriate to approve a plan that would require them to come back to this board for a variance?
That's a great question. Mr. Goddard or Mr. Federico, are you able to answer that?
So you're talking, Fred, about this wall right here that's labeled.
Yes, it runs a
that-
pretty good length along the property line that makes a pretty sharp corner around the Pondview Way condominium property.
I am. I guess I would ask Mr. Federico his opinion on that.
The building code requires a permit for a retaining wall that's anywhere more than 4 feet from the bottom of the footing to the top of the wall. In terms of structure in the zoning code, I think it needs to be somewhere upwards of 10 or 12 feet. I could be wrong. I don't have the book in front of me. But I think retaining walls of that may not necessarily require a variance. Again, I may be wrong. I don't have the book in front of me, but I don't think it's going to be an issue.
Okay. Yeah, I mean, I wouldn't, I'm not going to quote you on that, Bob. I know we went through a retaining wall issue on another project where we were told one thing and it came back another way and it was
Yeah,
approved. So I'm not comparing one project to the next, but definitely something to look into for sure. Okay, thank you. So let me pull up my. I cannot see my screen. David, is there any other? Okay, here we go. Any other questions or comments? Oh, Kathy? Yes, go ahead.
I have a question for the applicant. I know that they went to the Conservation Commission first, and did you apply for any waivers or variances from the Conservation Commission so that you could encroach and or fill some of the wetlands so that you could perhaps meet that 100-foot setback?
So if we go back to this overall plan here, that would be, so you're talking about filling all the wetlands up in this area.
I'm not,
Yeah.
I'm not the wetlands expert, but
Right, so
and I
to
don't
fill all
mean
these
to.
wetlands in here would exceed 5,000 square feet of wetlands, which is not permittable under the Wetland Protection Act in non-limited project conditions, which this would be. So I think that would be a difficult proposal for the Conservation Commission to allow. And then even if you filled this bulb here and brought the wetlands to here and kept it to 5,000, then you add your setbacks, boom, boom. Now you're within the front line setbacks to the street. We're back in the same situation, proposing to put the building right up against the road. So this, I believe, is the best location from a conservation perspective, for sure. And again, we still do maintain a reasonable setback to the property line, considering we're holding the residential setback at 20 feet and maintaining significant distances to nearby residential uses. So to answer your question, no, we didn't ask for a waiver or variance from the Conservation Commission from that, but in my experience, which is extensive with wetlands permitting, I don't think that would be a project that would likely be permittable.
But I mean, there is limited filling allowed, and was that explored at all to again trying to get you, to somewhere between 20 and 100 feet. And then also you talk about, if there was some limited filling allowed, that perhaps the building could run along Barefoot Road. And I guess what's wrong with that? I mean, you said that you wouldn't want it to be along Barefoot Road or something to that. I don't mean to put words in your mouth, but something to that effect.
Yeah, I mean, under the you can't just discretionarily, be proposing to fill in wetlands under the statute. So there's already going to be inherent problems where that proposal would come into play. And then furthermore, even if you were successful in eliminating some of this wetland area in over here, you're still going to be limited as to where the building can go, because you're pushed up, right, basically up against the edge of Barefoot Road. With the proposed use, this sets it back a little bit further. Furthermore, whether this was a building or whether it was a parking area or something, this area is still going to have to be utilized for any development scheme of this property. Right now, we're just talking about this variance request or this Dover amendment request with you guys because of it being the building location. So, swapping building for parking for building, I mean, we could have contemplated maybe something where a building was proposed in this location over in here, but again, we have the same problem and we're much closer to a residential use. This use here gives us the best, I think, setbacks to all of the surrounding uses, mirroring the interest of the wetland regulations as well, as evidenced by the actions of the Conservation Commission. So I appreciate the creative thinking on it, but I don't think that would be a successful application to the Conservation Commission.
Brad, if I can just ask one more question.
Sure.
Mr. Goddard, you just, you sort of jumped ahead to one of my questions where The property that's located to the, as it would be to the west, that is, still your property. If you located the daycare there, did you contemplate that, and what would your setback be there?
Let me pull this back up. So if the facility was placed in this location,
Yes.
we didn't do a design in this location. My guess is that that would be less desirable for the neighbors. We're trying to respect, those setbacks and all, but switching placing parking here and the building here, we're still going to certainly be within the 100-foot, because the 100-foot comes all the way out into the street. So whether the building was proposed here or here, the request to this board remains the same. It's not going to be substantially different. I mean, if we squoze a building in here, we're probably going to be within the 40-foot setback to the street. So we would need a variance from that. And the 25-foot from the back, we probably need a variance from that. Plus the neighbor has some encroachment of their property onto the property and onto this property, which would, that would disrupt them as well. Where we have the building currently proposed, we satisfy the front line building setbacks, we satisfy the rear line building setbacks. We even satisfy the sideline setbacks for structures. So all the typical zoning for building settings within the zones are satisfied with this proposal. It's just the between the zone setbacks, which is this 100-foot, that's the problem, which exists for here and it exists for over there. But if we moved it to the other location that you're talking about, I think we add additional problems, and we're compounding the problem by asking now for a variance or Dover Amendment exemptions from the zoning setbacks to front lot lines and rear lot lines, just in their own right of being even within the industrial zone. So it makes the request more substantial, I think, to put it in that more eastward location.
Okay. All right. Thank you, Mr. Goddard. Any other questions or comments from board or staff? Okay, hearing none at this point. This is a public hearing, and so if you have any questions or comments, really anything new, I know this is a continuance from last month. Anything new you'd like to address to the board or to the applicant, please, I normally say raise your hand, state your name, but David, are you there?
Yeah, raising the hand would be.
Anyone raising their hand?
Yeah.
So before you speak, please state your name and your address and address the board, not the applicant. We'll try and answer your question first, and if we can't, then we'll send it over to the applicant. So we have Ms. Bassett. Ms. Bassett, you are allowed to speak. I don't know if you're on mute. It doesn't look like you're on mute.
I am
Okay.
here.
Hello.
Thank you. My name is Mary Bassett. I'm at 3A Pondview Way. And again, for sake of brevity and not re-arguing any issues from last time, I would ask the board to review my letter dated March 24th, 2020, because you'll be able to see like on page 4, I actually cite, quote the entire Dover Amendment that's an issue, paragraph 3. And it's just says 2 things. One, which no one argues about, the use is allowed in any district. So this was the Commonwealth's grand bargain here with the cities and towns, right? We're going to say to the cities and towns who are really in charge, as we know, it's an all local thing, zoning. It's all a local requirement. They said, we are going to tell you to allow these certain uses that we deem protected uses in every single zoning district of your town. The second sentence, after they say that you have to allow that land or any structure on that land to operate a childcare facility, the second part of it, which is actually a little bit longer than the first, said, provided, however, that such land or structures may be subject to reasonable regulations concerning bulk, height, and of course, specifically list setbacks as a requirement. So there's never any quote Dover Amendment protection of their rights to, not have zoning applied. I want to make that clear that the zoning amendment applies to the use, and the zoning amendment makes clear to the town of Northborough, and you can apply all your zoning. Well, of course you can apply all your zoning because it's a structure and it's a building. So, but of course it has to be reasonable, because of course what they're preventing here is zoning out these things by saying, well, the daycare, can only be, certain size that is so unreasonable that they couldn't have a daycare. And actually that brings us to one of the last things the applicant's attorney discussed, was the town of Norfolk case, which is very interesting because it's been cited. And I don't want to go through it too much again, because on page 9 of my March 24th letter, I go through that letter in particular. There's two big things different about the town of Norfolk case. One, and this is the biggest difference, of course, the property had an existing structure. I heard counsel for the applicant talk about what wasn't allowed to build or couldn't build the structure, so therefore it was unreasonable. That's not that case at all. It's an existing structure in a residential neighborhood purchased by a person who is high regard in the childcare industry for this, had this wraparound driveway like you'd use. You go on and on, because the case is very interesting, but that case focused on diminishing or detracting from the usefulness of the structure, and much different to what we're talking about here, which is new construction. So we have new construction in an area that was at the time, at all times relevant, had the zoning on it when it was purchased by this applicant. With the zoning at the time, I think has been no question that the actual zoning bylaw is reasonable. But I do want to point out before we start that I have looked at the probably most of the zoning, the Dover cases in Massachusetts, and I've never seen one that asks for, put this as an exemption, a waiver. All the cases, and if you look at them, they're all a matter of degree, or they're all very different. They're all very distinct, but none of them, come up with this idea that, well, we're exempt from zoning because it's a Dover use. There is no such thing as that. I also think that the zoning bylaw, is reasonable as applied. These local bylaws are meant to be applied uniformly. So in fact, there is case law that says you can't really even grant like an exemption. I think you could probably grant some kind of a variance, so they were 99% zoning compliant. We got to give them 1%. That's what all the cases are about. If you read them all, the Boston College case, Trustees College, the Tufts case, they're all on these matters of degrees, not this. So why would Northborough apply the zoning? Well, because that's exactly what the abutters are here tonight for, because the zoning is meant to protect us. It's meant to preserve the character of of our neighborhood. And if you look at the Rogers case, which I happen to cite again in my July 27th letter, I think under that case, the court would deny this request. And of course, we have to address this argument that applicant presents about, well, the operation of a daycare center, doesn't create the same issues as an industrial district. And that has, no basis in fact or law. Again, the Rogers case is the first one to point out that childcare facilities are disruptive. And, right now, as I'm looking out my window, we can hear frogs or peepers or birds over there. And that's the kind of noise we want to hear. We don't want traffic and, you know, other that kind of noise generated from this type of facility. In fact, the same abutters objected to residences being over there. You know, this is a very small slice of property that acts as a buffer. And speaking of buffers, the applicant himself talked about, well, you know, here we have this 100 feet, we got to include the road. We don't include roads and buffers. This isn't how we do zoning. They're in the industrial district. They can't act like they're in the residential district and say, well, if we were in the residential district, it would be this way. Well, they're not in the residential district. They're in an industrial district, and it also happens to be on that line abutting the residential, which everyone knew all along, and it has the setback requirement. Why is that unreasonable? That is the most, actually reasonable application from zoning, that we can think of. And, I said this, but I have to say it again, the last time, that this 100-foot setback requirement is not what makes this lot undevelopable. It's the physical characteristics of this lot. It's this extremely odd shape, very odd shape. Look at it. It's covered in protected wetlands. That's a problem. I mean, if they could build in the wetlands, they wouldn't be here now, but that's what they bought. It's not the zoning bylaw that prevents them from building. It's really the lot's physical characteristics, don't support the construction. So I would ask the board to protect our interest, that denial of this does advance critical municipal interests, which are our interest. There's nothing, it was talking about it's a matter of reasonable and unreasonable. I think that this project is unreasonable. I think it's unreasonable for a developer to come in with a building, that is completely out of the zoning compliant. Think he can slap this, oh, we're going to use it for this, which of course changes constantly, the size of it, what they're going to use it for, profit, nonprofit. It's not reasonable to grant under these circumstances, these sets of facts. I think you should affirm the building inspector's decision and deny any relief.
Okay.
Thank you.
Thank you very much. Thank you for your comment.
Thank you.
Do we have any other, David, any other comments from?
Do I have an opportunity to respond, or should I wait until all the comments are?
Yeah, if you'd like to respond.
I'm happy with
Yeah.
with whatever way you prefer.
All right, well, let's, go ahead. Go ahead, Ms. Koji.
And I appreciate all of Attorney Bassett's comments and concerns. I think a couple of things need to be clarified. One is, the one statement that's been made is that this property, the project, is completely non-compliant with zoning. And I think we've both shown from Scott's maps and his statements that that's not actually the case, that we are in compliance with everything but for the 100-foot setback requirement. So I think it's important to know that the request that's being made for Dover Amendment protection is for one specific issue, not for don't apply any zoning to us. That's not what we're asking for, nor would we be entitled to under zoning, because as she stated, you are entitled to apply reasonable requirements for setback. The other issue that was mentioned was that the case law, and there isn't a tremendous amount regarding Dover Amendment's applications to schools, to daycare facilities. But there's nothing in that Rogers case, even though it deals with an expansion of an existing structure, that says that this law is not applicable to new structures, which would be in our case. And in fact, the Dover Amendment specifically states that it is not applicable to the exemption applies to expansion of existing structures as well as new. It's not saying that it's only applicable to one particular type of building. It's applicable to both new structures and old and expansion of existing structures for a very specific use. I also think the reason why there's not a lot of continuity between the cases is because it is so fact specific. You know, the board is going to have to review all of the facts as presented, and when they apply that 100-foot setback in light of what our issues are for building, they're going to have to decide, well, does that make it impossible for us to build this allowed facility on this property? And the answer is yes. And where in that case the answer is yes, then generally the finding has to be that as applied, that that bylaw is unreasonable. Then again, we're not saying we're exempt from all zoning. It's just that 100-foot setback requirement makes it impossible for us to put the exempted use of a daycare on the property. And we don't think that I understand the desire to keep the neighborhood as is, and that's what the buffer is for. And as shown on the map, the distance, although the road isn't necessarily included within the buffer, from an actual, when you apply it from a practical standpoint, there is that buffer between the residential area and where the proposed school would be. So it's, what Scott had said before, if we put it on this parcel, then we're much closer to those residences. And the best location for it on the lot is where it is proposed, and that maintains a sufficient distance between the closest residents so that it maintains, to the best of its ability, that residential aesthetic. And finally, again, the fact that the town bylaws specifically state that in a residential zone, you can have a daycare facility as of right. You do not have to apply for a permit at all, supports the argument that it's reasonable for us to have this application of this 100-foot setback be minimized in our case, because you allow it. There's at least five other daycare centers in your residential zones that have the much more minimal setback requirements. So we're not really changing, we're not putting in, as Ms. Backstrom stated, a bus stop, which would have an entirely different set of rules and is not protected by the Dover Amendment. So I think it's important that we look specifically at this specific property in relation to the industrial zone, in relation to where it is compared to other parts of the property. And ultimately, if you apply that 100-foot zone, the 100-foot setback, does it render our use null and void? And if that's the case, Roger says you have to find it unreasonable.
Okay, thank you very much. That was a good explanation.
Thank you.
That helps. So we have one more hand up for Bill Donovan. David, would you mind kicking it over to him? Mr. Donovan, would you mind stating your name and address for the record, please?
Sure. It's Bill Donovan, and I reside at 3B Pondview Way. I also submitted a couple of documents to Kathy Joubert to forward on to the board members. These were a document showing tax map 30, and it was also a document showing daycares in the area that Nisha commented on earlier. That particular map shows 18 daycare facilities or childcare facilities within a 5-mile radius of this site. The other document was the tax sheet, and I do have a couple of comments to make on that. On that document, it shows up in that left-hand corner that the applicant shows the parking lot. And it actually shows that as being a wetland area as well. So I'm assuming he's proposing to fill in that wetland to allow for that parking lot on this proposed project. I guess by a show of hands, has anybody from the zoning board walked this site or visited this site?
I mean, I can't speak for the rest of the board, but I've driven by there dozens upon dozens of times.
Okay, well,
Um,
I invite any of you, I'll give you a walkthrough around the site. I would like you to go visit that site, just to see what we are looking at here. I also agree with Attorney Bassett that you should deny this applicant. I did have a question for Nisha. I know you wanted to wait to the end for the questions. The 3 daycares that she had mentioned earlier, are those actual daycares in residential homes, or are those structures within a residential area? The other question I had was, I don't know if Scott presented at the Conservation Commission that this would be a 2-story structure. And I know that there was some questions brought up earlier regarding a basement, and it was determined that there would not be a basement. But with a 2-story structure, will that impede the groundwaters for the weight of the structure? Will that change any of the groundwaters in that area? And then I guess the final statement is, if this goes forward and gets built, would any of you send a child to this daycare center, being so close to the wetlands and the possibility of West Nile virus or Triple E? Thank you for hearing my comments.
Thank you, Mr. Donovan. So first question, and forgive me if I forget a couple. You had multiple questions in your statement, but has the rest of the board at least driven by, walked the property? So, I mean, we are clear upon what property we're looking at, front, back, rear, etc.
I've driven by it both on Barefoot Road and Solomon Pond Road at that traffic light many times. I'm aware of the limitations of the property.
Okay. Thank you. Everyone else? Dick? Yeah. You're familiar with it?
I've driven by the property numerous times and looked at it.
Okay. Mark?
I've driven by and made note of the layout of the property as I was driving by.
Okay. Paul?
Yep, same here. I've driven
Okay.
by a few times.
All right. Just want to make note that all the voting members are aware of the property. Gosh, he had a couple other questions that I've lost track of. Kathy, I'm going to throw you on the spot. Do you remember what were the other questions that Mr. Donovan had asked?
I think one of them was whether or not we would send our kids to the daycare center.
Would we send our kids there? Yep, that was one of them.
My answer would be no. My kids are in school.
Yeah, my kids are in school. I'm not going to speak for Mr. Rand, Mr. Rattan, or Ms. Backstrom, but I don't think they have kids in daycare. The other question, though, was, oh gosh, I lost my train of thought.
I think,
What was the
Mr. Chairman, Scott, there was a question, if I could, about wetlands or.
Oh, actually, sorry, Mr. Goddard, hold on to that thought
Yeah,
for a
sure.
minute. The other daycares in the area, how do the other daycares in the area compare to what you're proposing to build on this property? And then we
So-
can get, again, the wetlands.
What I did was when I saw that list of daycares, I went onto the assessor's map to see where they're located, what zone. And I didn't look specifically at the structure, but based on the name, perhaps it can be, I can look it up now if it's necessary, but
No,
for
no, no, off the
instance,
top of your head. I mean, yeah, we
so
don't have to get into
Church of
detail.
the Nativity is a nursery school in the general residential. Zay Integrated Preschool is in general residential, Neshoba Montessori School, general residential, and Northborough Extended Day, general residential. So I don't know whether those are houses that have daycares in them, but I'm going to guess that they are not.
Okay.
But again, I don't know. I don't want to state that I know, but again, at least 4 of those are in the residential district.
Okay. Okay. Thank you. Sorry, and didn't mean to cut you off, Mr. Goddard. Did you
No, that's
have
okay.
a
That was
comment?
just a comment. I'm not sure it's quite relevant to this discussion because any maps that show wet areas, for example, those are best determined in the field and by the Conservation Commission. So all the wetlands that exist on this property are mapped and shown on the maps that we've given you. Any other areas on the property are not deemed wetlands.
Okay. Okay. Thank you.
The chair?
Yes.
It's Fran.
Ms. Braxton.
All right,
Yeah.
so 2 things. One, I just want to clarify for anyone that may be listening, I certainly was not proposing in any way or manner that a bus stop should go there. I was trying to use the most obscure example when I was trying to get a clarification. The other thing, in our zoning by right, it's family daycares in residential, not commercial or well, I'm sure they make money, but they are family daycares, which are allowed by right in residential. I can't speak to how these others got there, but that is not what's being built now, so it's not a fair comparison.
Okay. Thank you, Fran. So I know we have one more hand up on this application. Sorry, Mr. McWilliams. I'm going to take one more from Rich Harnett from 1A Pondview. And I apologize. I'd love to listen to all you folks with your questions and comments, but for the sake of time, we have to move on a little bit. So Mr. Harnett, if you would you please state your name and address, even though I just stated it for you. Please go ahead and proceed with your question or comment.
Yeah, Rich Harnett, 1A Pondview Way. In addition to the aforementioned reasons why we object to having this structure and business built here, there's 2 other aspects that weren't raised. One is having it so close to those wetlands. We have a very, very bad mosquito issue around here as it is with the wetlands. Exposing children to mosquitoes, Triple E, et cetera, is I think one big risk. I wouldn't send a child there because of that. I think the second is, and you all talked about it, you talked about passing through the intersection where St. Gobain and Barefoot Road intersect. Although now with COVID, there hasn't been a lot of traffic, but I've been a resident here now for 2 years and I work from home and I face out onto Solomon Pond Road. And when pre-COVID was, that intersection, there were multiple accidents, multiple times, multiple days of the week. I see the Northborough Police pulling people over for speeding along Solomon Pond, and I just don't think it's a safe place to put a daycare.
Okay, thank you very much, Mr. Harnett. All right, I know I see a couple other hands. Appreciate your passion and your enthusiasm for this hearing, but unfortunately we have to move on. So do we have any other questions or comments from board or staff? Yes, Kathy.
Brad, I just have a suggestion for the board. And obviously this is entirely up to all of you, but as far as correspondence that you have received, you have 2 letters from the attorney representing Mr. Goddard, and you have 2 letters from an attorney that lives in the area and that I believe is also representing, some of the residents of the area, and both are, arguing or using the same cases, which makes sense to make their positions. But I would suggest to the board that you might want to bring in town council to advise the board, based on the fact that, you have, you know, again, you have two different attorneys with two different interpretations of some of the same case law. And I think it would just be helpful for the board in their deliberations to have town council review the material that's been submitted.
Okay, so based on that, do you recommend that we continue this hearing? And
Yes,
let
if-
town council kind of
yes, if-
intervene, for lack of a better term, but you
Yeah,
know,
if
weigh
you,
in?
yes, if you as a board agree to have, you know, town council review this and, you know, to give you their opinion on the case law and how it applies to this particular property and, you know, what your jurisdiction is, then I can go ahead and, you know, make that request of town council and yes, you would need to, you know, continue this to your August 25th meeting.
25th, yeah. Okay. Yeah, I mean, I don't have any, I'll leave it up to my colleagues. I can kind of go either way. I mean, we have no other, I'm not taking any other comments from attendees. Any other final comments from the applicants before we decide whether to close or to continue?
I just think that it, you know, there's been a lot of interesting discussion about, you know, the requirements of parking, lighting, the size of the building, you know, whether kids will, whether there's going to be traffic. Those are all very important issues that I think we need to make sure we're careful that those are not what's part of the issue for today's decision. Really, the only thing to be reviewed is the question that, I mean, I know I keep repeating myself, but the reasonableness of applying that particular 100-foot setback to our plan. And I think if we move to that next step, then all those other issues about traffic, lighting, parking, et cetera, will be addressed at a special permit. I just want to make sure that we're focused on the issue. And I think it would be helpful to have town council take a look at it, whether we should continue or not. You know, I'd leave that up to the board, but I think at this point you have from us and from Scott, all the information factual that you need to make that determination.
Okay, no, thank you very much.
Thank you.
Very helpful. Okay. All right. That being said, does someone on the board would like to make a motion to continue the hearing, to close the hearing? What?
I would like to make a motion
Yes.
to continue the hearing to the next month so that we can hear back from town council as far as a clarification on the Dover Amendment exceptions and their applicability here.
Second,
Okay, Mark Rutan made a motion to continue to August 25th. Dick Rand seconded. All those in favor?
I think you have to take a roll call.
Yes. Yep. Just wait for the hands to show up.
Mark Rutan, aye.
Fran
Dick Rand,
Baxter,
aye.
aye.
Dick Fran Backstrom approved. Paul?
Paul Tagliaferri, aye.
Aye. All right, and Brad Blanchett also approves. Did I forget somebody?
I think Fran and I spoke at the same time, but I'm
Yeah,
aye.
same time.
Yeah.
Okay. All right. It's unanimous. So we are going to continue the hearing for oh God, so I apologize. I have a million papers on my desk. 5 Barefoot Road, Northborough, Massachusetts, to August 25th, 2020.
At 6
Kathy, anything
p.m.
else? 6 p.m.
Just at 6 p.m.
6 p.m.
Yep, and I'll
Eastern
so
time.
the so the direction for town council is I will have him review the the application, obviously, but in particular, the correspondence that we've received from both attorneys and provide input back to the board.
Okay, thank you.
And Mr. Chair?
Yes.
Just for a point of clarification, because we are continuing the hearing, anyone who did not get to speak tonight because we're trying to keep within a hard stop would have the opportunity to provide new information at our next meeting.
Yes, yes. Thank you, Fran, or Ms. Backstrom. Yeah, Mr. McWilliams, I saw your hand was up. So I encourage you to join us next month, Tuesday, August 25th, 6 p.m. If you have any additional comments, questions, concerns, to please join us. And anyone else as well. All right. Give me 30 seconds to get my.
Thanks, everyone. Have a good evening.
Thank you very much. Have a good night. We'll see you next month. It's gonna be 30 seconds. All right. All right. 30-second recess so I can find my agenda. Where the hell is it? Oh, here it is. Okay. We're back. All right, next up is the continuation of the consideration of the petition of Berlin Landing Realty Trust for an appeal to build a, no, that's not it. No, it's sorry, next one. Sorry, Kathy. We continue that and we can, okay. To consider the petition of Amy Paretsky and Joanne Kraus for an appeal of the current conclusion of Robert J. Federico, CBO, Inspector of Building / Zoning Enforcement Office, that the property located at 329/333 West Main Street, map 81, parcels 13, 14, and 15 in the Business West District are now considered contractors' lots. So, Ms. Paretsky and Ms. Kraus, the floor is yours. David, would you mind
They are both
kicking them over to the panelists? Thank
Okay,
you.
can you hear me? This is Amy. Can you hear me?
Yes.
Okay. I actually have a presentation that I wanted to share just to make it easier to follow.
Sorry, Amy, would you mind just stating your name and address for the record, please?
Sure. This is Amy Paretsky, and I'm speaking as applicant tonight to appeal the 2020 interpretation by the zoning enforcement officer that 329/333 West Main Street is now considered a contractor's yard. But I did want to share my document. Is there any way to do that, David? I don't
But
see.
are you able to let Amy or Ms. Paretsky share
Yep.
her screen?
Just a moment.
Okay, thank you.
Can you hear me now? Hello?
I can hear you.
Oh, okay. It keeps going back on mute. I don't know why, but right now I'm not muted, so I'm gonna start. Everybody can hear me and see my screen?
Yes.
Okay. So good evening, everyone. Thanks for your time. I'm here to appeal the 2020 interpretation by the zoning enforcement officer that 329 to 333 West Main Street is considered a contractor's yard. A new owner purchased the property this year and began use of a contractor's yard without any permitting. The use of a contractor's yard on this property has been denied 3 times in the last 3 years. So why is it all of a sudden being allowed today? The following slides will explain the historical use of the property and the decisions made to ensure everyone understands the reason for this appeal. These pictures that are up on your screen were taken this year. As recently as 2017, the building enforcement officer rejected 2 applications for a contractor's yard on this same property. He stated, Business West does not allow other industrial uses contractor's yard. And Table 1, Part B, uses contractor yard, Business West are not allowed. In a memo from 2019 Kevin Labadini application for the contractor's yard at 329 West Main Street, I'm just going to close this. It was stated that there was a meeting of the zoning enforcement officer and the town engineer in September, which resulted in a zoning determination by the building inspector that the use by the proposed purchaser would be defined as a contractor's yard, which would not be an allowed use in Business West, where this property is located. In 2019, the second application was appealed to the ZBA. The ZBA also unanimously denied a special permit to allow the contractor's yard, stating A, the proposed use is not in substantial harmony with the master plan. The proposed site is not an appropriate location for the use based on 2009 rezoning changes. The proposed use will increase the nuisance of noise and fumes to abutting neighborhood and pedestrians. And the proposed use is substantially more detrimental than the existing non-conforming use of the neighborhood based on the increase of traffic, chemicals, and use of the property. In 2020, the parcels were sold and the new owner is now using these parcels as a contractor's yard. When I noticed trees being removed and numerous trucks being parked, I sent an email to the zoning enforcement officer. He asked me to file a formal complaint. Pictured here are some of the trucks that have been parking on site this year. The zoning enforcement officer stated that according to the new owner, there are approximately 18 trucks on site. Kevin Labadini's 2019 application asked if he could store 20 trucks. There is no difference between what the new owner is doing now and what Mr. Labadini applied for last year, except for the fact that the new applicant never had to come before the ZBA, the Groundwater Committee, to ask for approval on the proper permitting. In addition, there are materials now being stored on site. The storage of contracting materials has also been previously denied. There are also parking spaces with the yellow lines being drawn on the lots, and fencing and tree buffer have been removed. These are some of the pictures that have been taken over the year where all the trees came down. There's contracting blocks going up. There are tree logs being stored on site. Similar things that Kevin Labadini had applied for last year. The zoning enforcement officer replied to my complaint that a contractor's yard is not an allowed use by stating, he stated the contractor's yard is specifically allowed as per the ZBA special permit 87-16. What I'd like to point out is that the 1987 special permit is for the groundwater protection use only, overlay only. It does not pertain to the underlying use. Right in case 87-16, it stated, The petitioner seeks to build a garage and office, which are permitted uses in this zone. The parcel lies in Aquifer Zone 3, and the petition is entirely concerned with the aquifer protection portion of the bylaw. And if you read down the findings of facts and the conditions, now that I'm on the groundwater committee, you can see that the special permit pertains to groundwater. To confirm my interpretation, last week I hired a lawyer who specializes in land use and zoning and asked him some questions. His answers are in red. I asked him, does the 1987 ZBA decision 87-16 allow the use of a contractor's lot on the property today? He replied, the ZBA's decision in case number 87-16 grants a special permit to allow the use under groundwater protection overlay district provisions of the town's zoning bylaws. The purpose of the groundwater protection overlay district provisions of the bylaws is to protect the town's groundwater natural resource. They are in the nature of environmental protection regulations. They do not allow uses which are not permitted in the underlying zoning district. Nor does the groundwater protection overlay district special permit allow the contractor's lot use to continue in perpetuity. Where the bylaws were amended, making the contractor's lot use non-conforming, if the use continued without a 2-year lapse, it would now be a prior non-conforming or grandfathered use. So in summary, about this slide, the special permit pertains to groundwater only. It does not allow or protect an underlying use. The second question I asked him is, if the site began as a contractor's yard in 1987, but hasn't been run recently as a contractor's yard for more than 2 years, does it lose its grandfathered non-conforming use? He stated yes, under section 708.050 of the bylaws, a non-conforming use or structure that has not been used for a period of 2 or more years shall lose its protected status and be subject to all the provisions of this bylaw. According to Mr. Gould, during the denied 2019 application for a contractor's yard, ACV does not store vacuum trucks on site today, but rather uses the site for a business office and equipment storage. There is no full-time mechanic on site anymore. As was shown in the prior applications, any non-conforming use as a contractor's lot was lost long ago, which is why Mr. Labandini himself was not allowed to operate as a contractor's lot by right. The last question I asked, because in the reply from the zoning enforcement officer, he stated, the non-use of a property is based on the ability of the owner tenant to conduct the activity either by right, by special permit, or variance. So long as the company has a presence on the property, the clock for 2-year non-use does not start. Thereby, ACV has always held the right to operate the property as a contractor's yard. My question to the lawyer was, must the site be abandoned for the clock to start on non-use? He replied, no. Per section 708.050 of the bylaws cited above, cessation of the use begins the running of the clock on non-use. So just because ACV has had a presence on the property, it doesn't give them the right to run as a contractor's lot in perpetuity. Here's a site plan from 1989 that shows 3 properties. 345 on the left was originally Zeco. That was a site where they stored their trucks. If you follow the arrows across the site, these arrows was the path that they drove to 329, where they had an office, where they had their offices and a garage to repair their vehicles. According to the 87-16 decision, 333 West Main was included to provide room for the septic system and recharge retention areas. If we suddenly allow a contractor's yard by right on 329-333 West Main Street, there will be no protection for our groundwater 3 zone, as there wasn't proper parking permitted, including drainage with oil separators. Any fluid leaks will go straight to the groundwater of the neighbors and abutting properties who are on wells. This 329 West Main Street site plan shows lot 333 as empty and states it was used as a travel path between the other 2 properties, which were owned by Zeco back in 1989. In conclusion, I ask that you support my appeal and overturn the zoning enforcement interpretation that 329 to 333 West Main Street can operate as a contractor's yard by right today. The summary of facts that I just stated: a contractor's lot has been denied on 329 West Main Street 3 times in the past 3 years, twice by the zoning enforcement officer and once by the ZBA. Mr. Labandini and the other applicants had to follow the proper process. Every contractor yard following them should also have to follow the same process. Ignoring the process would not only be against our zoning regulations, but it would also circumvent the ability of the ZBA and the groundwater committees to make proper decisions. Number 2, special permit case 8716 is a groundwater special permit, and that does not give the right to run a contractor's lot in perpetuity. Number 3, approximately 18 trucks are being parked on a previously undeveloped gravel lot that housed a septic system and retention recharge areas. A contractor's lot with 20 trucks there was denied in 2019. 4, contractor yard materials are being stored on site today that were also denied in 2019. Fencing and tree buffers have been removed. And number 5, ACV, the previous owner, hasn't been more than a general office space for years. If there was a contractor's yard there in 1987, the non-conforming use protection has expired, and the parcels on 329 and 333 West Main must now conform to current zoning. Thanks. I just don't understand how there could be 3 denials and all of a sudden it's being allowed by right. But thank you for your time. I'd like to actually open it up to Joanne Kraus and the neighbors too, because they had statements to make.
Is that okay?
Yeah, well, Joanne was, oh yeah, Joanne's on it with me.
Yeah, I'm here. So thanks, Amy. That was a great summary.
Sorry. So Ms. Kraus,
Yes.
I know you're the co-applicant.
Yep.
Applicant. Would you mind stating your name and address for the record, please?
Okay. Joanne Kraus, 10 Buck Hill Road, Northborough.
Thank you.
Okay, thank you. Thanks for the opportunity to come before you today. I just wanted to say that, you know, I've lived in this neighborhood for a long time, and I got up in the town meeting a couple weeks ago and stated that I had been fighting such businesses for 25 years and have come before you several times. And last year, when the site, you know, the contractor's yard was denied, I was really shocked to see, as I'm driving by, a contractor's yard in this very property. And I'm just wondering how on earth this can happen when we have these bylaws in place to protect us. And all of a sudden now this huge company is now in business running. And even after reporting that this was going on, it seemed as though we never had that meeting last year, and that the Zoning Board of Appeals has never denied it. So I'm just curious as to how this can possibly happen in our town.
Okay, well, thank you. I mean, that's why we're here to have this discussion. So do you have, Ms. Kraus or Ms. Paretsky, any other questions before I open it up? I mean, I definitely understand your frustration because we've as a town, as a board, we've debated this before. So I definitely understand, again, your frustration.
Yeah, it was, I mean, somebody got up at town meeting and said the ZBA process, it works. And I'm really wondering, does it? Because it doesn't seem to be working here from what I can tell.
Yes. Yep. Yeah. I mean, every application stands on its own merit, and the last one did, and we rejected it. So this one's different. So that's why we're here tonight. We're just gonna debate it and have a conversation. So
I guess what I wanted to state is he never actually applied, so.
well,
So the
that's part of the discussion.
Okay,
That's part of the discussion as well. Yes. Yep. No, I'm with you. So no, I appreciate you ladies bringing the application up, and we're gonna have a discussion. Here we go. So that being said, opening up to the board, do any board members have any questions or comments on the application, or I should say the it's not the application, but yeah. Let's talk about 329.
The appeal.
The appeal. Thank you. The appeal of 329 West Main. Thank you, Bob. Thank you. All right, any questions? Yes, Mark.
Comment. All right. Yes, this is an appeal. First of all, is there any more presentation from anyone else as far as this appeal goes? So is there any further presentation that you have on your list of participants or attendees? This is on the presentation, not questions, but just a further presentation.
If I may, through the chairman.
Yes.
There is an attorney for the property owner, George Connors. I think he has his hand risen. He may want to make some statements in the form of a presentation.
All right. David, do we have somebody? Is he on the list to speak?
Yeah, he's coming in now.
Yeah, I do see George Connors. Yeah.
George Connors. Okay. All right. Mr. Connors, if you would you please state your name and address and your affiliation with this project?
My name is George Connors. My address is 10 Southwest Cutoff, Northborough, Massachusetts. I am an attorney representing SNS Hudson Holdings LLC. I am also an engineer at Cornerstone. I can tell you that we are working as an engineering firm on the matter of addressing Mr. Frederico's request to deal with a parking plan for that site, including some other matters on that site, which are not going to be discussed tonight, and for addressing a holding tank on that site that apparently is missing. We have signed a contract as engineers with SNS to perform the engineering and survey work, and I've talked to Mr. Frederico about that at length today. There will be some sort of a submission relative to that sometime towards the end of August. I'm also an attorney representing the interests of SNS with respect to the use of the property, and I'll be happy to go through that in some detail upon the board's deliberations, either now or later on. Basically, it's our position that the site is a pre-existing, non-conforming contractor's yard from the 1987 zoning bylaw. It has never been abandoned. There is two cases that are very instructive on this. One is Dial Away versus the Zoning Board of Auburn, where the court found there had to be an intent to abandon and voluntary conduct. That's an appeals court case. that as a predecessor, the Derby Refinery versus City of Chelsea. It's a SJC case. And in that particular case, there was a facility that was mothballed. There was a letter sent from the facility to the Coast Guard indicating that they would no longer be providing service. That did not rise to the dismissal or the loss of the pre-existing non-conforming aspects of that particular site. So I believe that this particular site at 329 and its adjacent parcels that are shown on the application plan back in '87 for the groundwater permit are grandfathered. I would note that at that time, there had been a couple of previous uses on that site. One included a welding shop with car repairs. There had been a building out front that had been replaced, and then in sometime around 1987, when they went for the 87-16 permit, the plan showed a small existing concrete block building that was going to be amended to be a bigger building at that location. I'm happy to respond to questions and comments.
Yeah, so Mr. Connors, well, thank you for that. One of the things that I'm concerned with is, so I'm looking at a timeline for 329 West Main from a previous applicant, and the applicant had a similar use. What makes you, for lack of a better term, what makes you special that you didn't have to come in front of the zoning board early on and say, well, I want to do this. Now you're saying, well, I'm doing this, and now I'm asking for permission.
I don't know that we're necessarily asking permission. I don't believe we need permission. I believe we're grandfathered. I'm not sure about the other case. I was not involved with that. If I looked at that in more detail, I may have a different opinion than what was decided there. But the contractor's yard was allowed, and under the powers tests, there are 3 tests that may indicate that landscaping business could go in there. I'm not opining on that at this stage. I'm simply saying that changes of uses that are grandfathered do have to meet certain tests, and there may be an opportunity for that to have happened. I do not know all the details of that case.
Okay, so so Bob, yeah, thank you, Bob.
Yes.
You mind just chiming in? Thank you.
Sure. My take is that he did not have to go for any special permits because he was adhering to the conditions set forth when the special permit was issued back in 1987. Let's go back and talk about that for a minute.
Yes.
First of all, under the underlying zoning regulations in 1987, a contractor yard wasn't allowed by right use.
Yeah.
Okay. The groundwater permit, which is the 1986 permit, in the decision, and I'd like to bring up the fact that Amy talked about some statements that are in the beginning of the appeal notes. I'd like to recommend that, we need to recognize what is actually in the decision and not in the previous notes that lead up to the board to make the decision.
Mm-hmm.
And the board did issue a unanimous vote special permit to allow the constructor office's garage yard as a contractor. So in 1987, they had the allowed by right use as a contractor's yard, and the special permit for the groundwater had a special permit to be operating as a contractor's yard as well. Okay, that's the basis for this whole discussion. Okay, and the way the zoning works is that as long as that use is maintained, okay, or it has the ability to be maintained and is not expanded, okay, that use is allowed to stay as that use regardless of what happens in the future with more current zoning, like right now, the zoning does not allow for a contractor's yard. However, this particular case doesn't apply because this is a pre-existing conforming use. Okay. When I went out there and did my investigation, there were some things that I had raised questions about. The complaint that came in to me was somewhere around 35 pages. And after sifting through everything, there was only about 3 or 4 items that actually pertain to zoning specifically. Okay. Part of it was parking of the trucks. You know, I asked about the parking of the trucks. I know chemicals were involved with the previous 3 or 4 applicants, and that is why they were either denied by me or they were denied by the ZBA. These particular trucks, I was notified and I was shown that the trucks come back clean and they document and they photograph every truck that comes back. In terms of the tree service company that's been there for quite a while, they are a tree service only. So the only chemicals they have on site is the fuel and the oil to operate the chainsaws and the trucks. They don't fertilize. They don't put out any insecticides. They don't spray anything. I also inquired about the noise factor, and I was told by the company that operates the vacuum trucks that all of the trucks are manufactured after 2015. And in 2015, the Federal Department of Transportation required DEF, which is diesel emissions fluid, diesel exhaust fluid, which is an additive which takes away the odor of the diesel trucks and significantly reduces the sound emitted from those trucks. So when I looked at all those items combined, I said, okay, the use is continued and allowed. And what they're doing is no less harmful to, you know, the environment, you know. So my take was a lot of the fears that would come along with having these trucks there have been allayed. Now, when I did my inspection report out there, there were a few things that needed to be done. The special permit did require that some sort of an underground tank be installed and maintained. As you all know, that when there's a condition on a special permit, that condition has to remain in perpetuity. And there's been some debate about whether or not the tank was either installed or removed without anybody's notice. But the owner fully intends by written word and by discussion today that they intend on figuring out what is going on with that and get that tank installed. There's a rumor going around the tank was removed because the federal EPA has a time limit on the length of time the tanks can be in the ground. And the suggestion is floated that the tank was removed and the hole just filled in. So that is due to be corrected. Also, in terms of gravel parking, in terms of the zoning bylaws from the time that the special permit was granted, parking surfaces were not required to be paved. They could be gravel, they could be packed gravel, they could be binder, they could be finish coat. And with what the caveat was with suitable drainage. Obviously, I don't think there's suitable drainage out there, and the owners of the property intend on taking care of that as well. I think I have covered everything. In terms of the previous, and I may be repeating myself, the previous 3 attempts for having a company go in there, the big thing they were doing is they were having chemicals, they were having pesticides, they were having fertilizers, 1,000 gallons of diesel fuel, and that sort of thing. So when you talk about an interpretation form, some people take the form, I say it's not allowed, they go away. Some people take the form and they say, well, maybe we can apply for a special permit or variance and try it anyway, which is what Labadini did. And then the ZBA made their decision, which is fine. So for those reasons, I don't necessarily think that they needed to come to the town for any official action because they were continuing an approved use, okay? In terms of the abandonment situation, there are court records that say as long as the company is there and they have the ability to do that operation, that is not an abandoned use, okay? The abandoned use would have to be intentional, and there would have to be nobody there from ACV for a period of 2 years in order for the 2-year exclusion, if you will, or the non-grandfathering to take effect. So taking all that into account, that's why I said it's, as long as you're adhering to the special permit requirements, you're okay. I hope that clears some things up.
Can I just speak to that one more time? Because I was the applicant. Usually the applicant can
Yeah.
reply.
Talk to Brad and have Brad approve, you know,
Okay.
coming in on this.
Sorry. Brad, can I just speak to what Bob said?
Brad, are you there? You're muted, Brad.
Yes. All right, I'm here. Thank you. No, thanks, Mark. No, Amy, we're gonna wait and listen, make sure Mr. Federico is all set. If he has any other comments. Bob, you all set?
To this point, yes. I know there's going to be more questions and discussions. I'm happy to answer them.
Okay.
But in terms of any kind of a statement, I think I'm all set.
Okay. All right. Thank you. Thank you. All right.
Could I just speak to something he said, Brad?
Yes, now you can. Yes, Ms.
Okay,
Paretsky.
Thanks. I just wanted to speak that I spoke at length with the lawyer about what Bob is saying about it running in perpetuity. And if it was a use variance in 1987, it could run in perpetuity, or even a special permit for use, it could have run in perpetuity. But what it was a special permit for groundwater. The use was allowed by right, like Bob is saying, the use was allowed by right, but it meant in 2009, when the zoning bylaws changed, it became a non-conforming use. Just because there's a special permit for groundwater, it doesn't hold the use underneath it to stay the same. He told me that the underlying use, if it was allowed use, would become non-conforming in 2009, which would mean that this contractor's lot, if it was ran as a contractor's lot, in 2009 would become a non-conforming use, and that would start the clock if it stopped. If it was a special permit for use or a use variance, then it could run forever in perpetuity because of those special permits. But because it was a special permit for groundwater and the use underneath it was an allowed permitted use, when that use changed in 2009, it became a non-conforming use. So if anything expands, if they start adding trucks or doing anything on the other lot, it would have to apply for non-conforming to non-conforming, like Mr. Labandini did, or they would even lose their right if it had stopped for 2 years. I just want to make that point. They're trying, I think Bob's trying to say that the use is running with the groundwater special permit, but I really did. I paid a lawyer and I talked with him in detail to make sure I understood this. And he said that that use is not tied to that special permit. It was a permitted use, which became non-conforming in 2009. And you might want to run it by town council to get a second opinion. I mean, I know what the lawyer was saying was right, but if you want to check on what Bob's saying.
Okay. Yep. Bob?
I've actually never heard of that before. Number one, in terms of the decision and the conditions with the zoning special permit for groundwater back from 1987, there is no limit and there is no sunset date. I would like to ask your attorney that you paid for exactly what chapter and verse he's getting this from, because I've never heard this before. I was always under the impression that special permits and uses allowed by right are allowed to continue in that fashion in perpetuity, as long as it's maintained and run according to the conditions that was in the original underlying permission for the use.
Thank you.
Mr. Chair, for the record, can we
Yes.
ask to have, the name and of the attorney and determine, I mean, this, once again, we have two different attorney, or we have an attorney interpretation of something that may or may not be, yeah, I mean, it's all up to interpretation.
Right, right.
But we would need the name of the attorney and the law, the sites, right?
Yeah, I mean, Ms. Bretsky.
Sure. I could even send you the email that he sent me because I had him write it up so I wouldn't, confuse the statements. I asked him to put it in writing. So if after this you want me to forward it to you, I could.
Yes, please send it through Kathy Jubert, town planner.
Sure.
So
Brad,
it's all on record. And then
just for the
Kathy will send it along to the board and town staff.
So Brad, just for the minutes, who's the attorney? Amy, if you could just.
Oh, it's Mark Lanza. And I did have to pay for his services. I actually had to pay for this appeal too, to come before you tonight.
All right, so noted.
Mr. Chair, if I
Yes, yes.
just to back off Fran's question for the attorney, is it possible to get like Northborough's town council to sort of answer some of these questions as opposed to the lawyer for either side, just as from our own perspective?
We are the other side. So yeah, so it'd be town council, yeah.
Yeah. If that's okay.
So Kathy, is that possible to have town council weigh in on this?
Yeah,
Application.
absolutely. I mean, you'd have to do the same thing, with the other, as you did with the other application, continue. I mean, I know that there's still people that want to speak tonight, but, to continue the hearing to August 25th. And we would just need to discuss, I mean, it was a little more clear cut on the other application, what we were asking or what I was asking, town council on behalf of you. So we would just need to discuss that a little bit tonight as far as what, the questions. I mean, I've certainly got the gist of it, but just to make sure that I'm asking what you need.
Okay. So Fran and Paul, both of you asked for town council. So would you mind just diving in a little bit more on what exactly you're asking for interpretation from town council? Fran, I'll start with you.
Okay, so I mean, specifically, the appellant references section 708050, 708050, where the non-conforming use that has not been used for period. We need a legal definition of what they mean by used, because Bob's interpretation and experience is that as long as they have a presence, the attorney that the appellant hired said it actually be like something has to be happening. But that's not a legal term. I think that's the gist of it. But that's at least one point that we would be asking. I mean, while we have the town council, my understanding is the the zoning enforcement officer impression was that this new non-conforming use was not more detrimental and therefore, in his opinion, did not need to come before us at all. And that's what's being appealed, right? It's not that it's no longer a conformed use. But it's not different enough. Anyway, never mind. I'm going to strike all of that. Just stick with the 50.
Yeah, Mr. Chair, I kind of agree with that.
Confusing.
Just, I guess, clarifying the sunset clause on the use and whether or not it's a groundwater protection overlay versus a special permit with use. Just that, I think that question goes a long way in sort of guiding our decision. some of it at least.
Mr.
Much
Chairman, I
better
have a
said. Thank you,
question.
Paul.
Yep. Go, Dick.
What is the date of the building inspector's decision that's being appealed?
Good question. What
Oh,
was
it's the
the,
spring.
Through the chair, it was around, I think it was April 28th, Bob.
all right, yeah, hold on, Amy. We're gonna, I'd like to hear that from building inspector, please.
I'm looking for it. My response letter went out on April 28th, 2020.
Okay, and the appeal was filed with the town clerk's office on June 15th, correct? Well, my read of chapter 48, section 15 says an appeal has to be taken within 30 days. This is way beyond the 30 days.
I
This
know
is
we were on
legitimate
time
appeal.
with our appeal.
Now, hold on, Ms. Kraus, hold on. We're debating as a board and a staff. So I will let you know if you have any questions. I'll keep you posted.
Through the chair.
No, hold on, please, Ms. Pretsky.
Sure.
So my question is this a timely appeal of the building inspector's decision if it's beyond the 30 days?
I mean,
Can I say something?
no, please
Who's
wait.
late getting
Please wait,
back
Ms.
to
Kraus. No, please wait. Point of order, please wait. I know we're in different circumstances with the pandemic. So a 30-day period may change, but I will defer to town staff on these questions and comments, because I mean, the whole country was shut down from mid-March until, I mean, some parts of the country is still shut down. So I'm going to defer to Bob and Kathy on this.
So that's something that we can add to, the questions for town council to clarify that.
The 30-day window and things like
Yes.
that. Yeah. I mean, we're in what are they trying to say? Different circumstances, I guess, you can, for lack of a better term.
I just would like to say,
All right, so Ms. Kraus, would you like to make a comment?
yes, because when I filed my appeal, I did not hear back from Bob Federico within the appropriate number of days. So he was late getting back to me. And then I filed my appeal well within the 30 days.
Okay.
And he apologized to me for not getting back to me on time. And I accepted his apology, but I know I replied with my appeal on time.
Okay. So
And I have
I don't
the
think we're
email
questioning. I don't think we're questioning your timeline.
Yeah, Mr. Rand is questioning whether we applied timely, and we did.
Okay.
The issue is that, when I submitted my objection to the land there, and then I did not hear back from Bob in a timely manner, and I accepted his apology in the email that I still have, and I can forward to you, that it was fine. We were not late filing this appeal.
Okay. Nope.
And we
And
provided all the paperwork that he asked for. And it was 100 pages of proof documents that he asked us for.
okay.
Through the chair, Brad, I also have a reply
All
to.
right. Yeah, no, I just want to reply to Ms. Kraus, and we're not questioning your timeliness as far as a response. So don't worry, we're not questioning.
But he
that.
was. Dick Rand was questioning our time.
Okay.
What he was
Okay.
doing.
He just
Sorry.
wanted to make sure. He just wanted to make sure that everything was timely. But I mean, under extenuating circumstances, don't worry. I'm not as a chairman. You have my word. I'm not going to let the timelines ruin any of your application or your appeal.
I had a statement too through the chair.
Yes, Ms. Paretsky, go ahead.
I can probably find it in an email, but I actually worked with Kathy on the date to passing it in. And I have emails from her saying, don't worry, Amy, this is within the date. So it was on the date. I was in back and forth with Kathy the week when I was in turning in all the documents.
Amy,
Mr. Chair, I mean, just for the record, it's just not in our packet. We have the original complaint in February. We have the actual appeal filed in June. We don't have the actual decision that was appealed. And that's the only time frame that is currently in question, and rightfully so, because we don't have the paper. Not implying that anyone did anything wrong or is trying to mislead anyone. We just don't have it. So once we have it, we can determine whether it was timely.
Correct. No, thank you, Fran. I mean, that's one of the things. I'm not going to let, we're going through crazy times here. So I, as the chairman of the ZBA, I'm not going to allow like, oh, you missed the deadline by this day or that day. Like, don't worry, please. And Kathy, if you don't mind just having that in writing.
Sure.
Don't
Yeah.
worry.
Well, I mean, I'll put
Please.
together, I mean, whether you have additional questions or not, but I'll put together the list of questions. And then once we receive, the information, Amy, the email or whatever that you're going to forward to the board, you can just forward it to me so that we can then, include that with the information to town council.
Or the letters from the questions from the lawyer that I have.
Yeah,
Okay, sure.
an email or multiple emails, whatever it is.
I thought you meant the email about the date to pass it in.
No. What you and I were just talking about was the timeframe to the deadline for submitting something for the ZBA to get it on the next agenda. That's the only deadline that you and I were discussing. What Mr. Rand's referring to is by state statute. So that's what we'll get clarified from town council.
Right, but I talked it out with you and we talked about the date to appeal to Bob's decision. And you told me that this was the date that I had to appeal it by. And that's the date I went by, so.
No, what we discussed was when you had to get a filing in order to be on the next zoning board of appeals agenda.
Oh, okay. Well, I have an email anyway, so I'll find that one also.
Okay. Thank you, Amy. All right. I know we're continuing 329 to August 25th. But so before I open it up to questions and comments, do we have any questions and comments from board or staff?
Yeah, Mr. Chair, can I ask a question?
Yes.
How is the property currently being used?
Good question.
And I guess more specifically, I guess and this might be a question for either Bob or for Mr. Connors. The owner is S&S Hudson Trust. What businesses are currently tenants of the 329 property? So.
Yep. No, so it's a great question. And I would like to hear from both the applicants as well as town staff on that. And so, Mr. Federico, would you mind starting with who are the tenants of 329, 333?
I don't know the actual company names. Forgive me for that, but there's the welding shop that's been there for a long time. There is the vacuum trucking, which is actually a leasing company that leases out these vacuum trucks for kind of extended periods of time to different companies. The tree service is there. And there's
sorry, Mr. Federico, what's the name of the tree service? Off the top of your head?
I don't.
But there is
I
a
don't
tree
have that.
service.
It's a tree service, yes.
Okay.
And the other one is an applicant that you folks can continue to next month, which is
Yeah, the granite countertop.
Granite showroom countertop.
Yeah.
company.
Yeah.
Those
Okay.
are the ones that I'm aware of. In terms of more details, I think George can probably give you more detail on that.
I wish I
Okay.
could. I think everything you've named is what I know. Did you get
Okay.
that?
All right. Thank you, Mr. Connors. Ms. Paretsky and Ms. Kraus, would you mind elaborating on the tenants, the current tenants at 329/333 West Main Street?
Me, it looks like a contractor's yard is in there. I don't know specifically, but I wanted to ask Bob a question. Why,
Well,
why
Ms.
is,
Kraus, hold on one second. I mean, we're going to answer this question first, and then I'll hold your question.
okay,
Don't worry, I'm not gonna blow you off.
okay. No,
But-
I think to me, it appears to be a contractor's yard with all the activity that's going on there and all the trucks that I did not think were allowed.
Okay. And as far as that, I mean, what are the hours? What kind of trucks are coming in and out of there? So I know you're in a butter. So just to give everyone an idea of what's going on there.
Paul Kraus, Ken Buck.
No, still, hold on. Hey, David, hold on. Oh, Ms. Kraus, is that your
It's my husband.
partner, spouse, husband?
Yeah.
Whatever, at this day and age.
Brad, there's a gentleman that would like to speak that is also an attorney for the property owner, Mr. Lou Montzoris. I know he's an attorney representing the property owner also, so he might be able to clarify who the tenants are.
All right. Before we do that, Kathy, I'd just like to hear Ms. Kraus, just because we already had her, and then afterwards, be happy to hear about the tenant. So, Ms. Kraus, if you don't mind continuing, or Mr. Kraus. And so, Mr. Kraus, you're here. Would you mind just stating your name and address for the record?
Paul Kraus, 10 Buck Hill Road. The trucks that you saw in the pictures are all lined up. They're, if you just go by diesel tanks on those trucks, 20 trucks at 50 gallons, there's 1,000 gallons of diesel on that property now. There are tractor trailer grapple trucks dropping those logs off. And when they drop those logs, they shake the house. And I live pretty far away. I'm not a close butter to this. So there are grapple trucks that are being used. It's Heritage Welding that's been there forever. And they clearly are running a good business on that left-hand corner. The dance studio has left and they're down the street. So I can't speak to anything else other than the trucks that are coming in, the grapple trucks of logs and the big white vac trucks.
Okay. Thank you very much. And so, sorry, Kathy. Yeah, you were mentioning someone else. I'm happy to hear from them.
Yes, I was just saying there's a gentleman, Mr. Montzoris. I'm sorry if I'm saying that incorrectly. He's an attorney for the property owner. And I know that he had his hand up, but I'm just saying, not telling you to take people out of order, Brad, but I think can answer your question about possibly about who the tenants are.
Yep. Mr. Manzori.
Good evening, Mr. Chairman.
Thank you. Yes.
So I don't represent SNS Hudson Realty Trust with regard to the zoning issues that Mr. Connors is representing us on, but I am familiar with the property. I have worked with Mr. Federico. I have met him at the site several times, and I do know who the tenants are, although I may not know their names as well. Mr. Federico was accurate with regard to who we have there. We have the vacuum truck company that leases out vacuum trucks to others. So they come on, they fill out a rental application, they can take a truck for a week, a day, a month, or a year. In these times, there are more trucks parked. Usually they'd all be out for the summer in the construction season, but because of the COVID, they are more so on site at this point. There is the tree company who's been there, I believe, for 9 or 10 years. He doesn't do any processing or any servicing of any vehicles. He simply stores his vehicles there and has an office upstairs in the premises. He does have logs that are piled there. They're not cut there or done anything. They're just dropped off there. And right now, the only reason they're there is because a fence had to come down because National Grid is running new electrical service to the building. So he kind of left them up just to maintain somewhat of a buffer. But those are not being processed there. There's Heritage Welding, who has the right to be there per previous special permit, I believe from the 80s or 90s as a contractor's yard. And they've been operating there ever since. And they're maintaining the back building as well as 2 bays in the front building, some office space upstairs, and a bunch of space in the yard. And those are the tenants at this point.
Okay. Well, thank you.
And
Oh, go ahead, Kathy.
this is Joanne. I was going to say,
Oh, Joanne.
the middle property had nothing on it before. It did not operate as a contractor's yard at all. There was absolutely nothing on that property. It was empty for years and years and years.
Okay. No, thank you, Ms. Kraus. Thank you. So, I mean, that's one of the things I was going to bring up is why all of a sudden that we have a bunch of trucks sitting on 333 and we have a handful of logs where previously, before we dealt with another applicant, those things aren't there. So I think that's why we're here tonight. And again, we'll debate this August 25th, but I think that's what we're coming down to, is the fact that all of a sudden we're seeing a lot more activity at this property, and you're not asking permission, you're asking forgiveness, Mr. Montezori. Forgive me if I mispronounce your name, but I think that's where we're heading.
Thank you. It's Montzoris. You got it close enough.
Montzoris, close enough. But I think that's where we're heading. And that's the debate. Is other organizations asked for permission, and they're looking in this organization that's doing trees and logs, all of a sudden they just appeared during a pandemic, and now they're asking for forgiveness. So
Mr. Chairman, if I could
please
respond,
keep that in mind.
If I could respond to that, the tree guy's been there for 9 years. The welding company's been there for 20 or 30 years. So the only change was the new leasing company, which was replacing the old leasing company, which did the exact same thing. There's been no other change at the property.
But there was absolutely nothing.
So Ms. Kraus, please, point of order. I understand you're very passionate about this.
The trucks were parked out on that lot over the years, except when they were putting in the new septic system, they had to move off of that lot.
Okay. All right. Well, we'll continue this to next month, but I just, as a resident, and I've been keeping an eye on this, and we all have. I mean, because there's a bunch of applications that have come through for 329. So I don't know. I don't know what to say.
Mr. Chair?
Yes.
So will you entertain a motion to continue the hearing for the appeal of the zoning enforcement officer's decision of 329 West Main Street to our August 25th, 2020 meeting at 6 p.m.
Second.
Yep. All right. All those in favor?
Roll call.
Roll
Fran,
call.
aye.
So Fran, made the motion. Fran Baxter made the motion. Dick Rand seconded the motion.
Dick Rand, aye.
Paul Tagliaferri, aye.
Aye. Mark?
Mark Rutan, aye.
All right. Brad Blanchett, aye. So again, for the applicants, Ms. Kraus and Ms. Paretsky, this hearing is not closed. We are continuing to August 25th, 2020. And we are going to continue the conversation, and we'll weigh in on what town council says. But I appreciate all your questions and comments, as well as from the applicants, Mr. Matazoris, and yeah, all the other applicants.
Thank you. Thanks for hearing us.
Thank you.
See you next month.
We'll be here.
So Brad, the only other thing that I had on the agenda was your approval of minutes. You have, I had 4 sets listed, but you haven't received the July 1st minutes yet. So you've got October 22nd, 2019, November 26th, 2019, and January 28th, 2020.
So candidly, Kathy, I'm behind on the minutes, but I'll defer to Fran, Dick, and Mark, and even Paul. But the decisions I promise I will review them tomorrow and let you know about those. But as far as the minutes,
yeah, I'll also be sending you out tomorrow because you have 2 decisions, that have been circulated, and then the third decision for 1 Lyman Street will go out to you tomorrow.
Okay.
For review.
Okay, great. Yeah, I'll hunker down and review those. But if defer to my senior colleagues if you have no issues with the minutes.
I have no issues with the 3 minutes as described from October, November, and January.
I move that we accept the minutes then as submitted.
I'll second.
All right, for Mark and Fran, and then Dick. Dick also thirded. Thirded, if that's a term. All right, all those in favor?
Fran, aye.
Dick Rand, aye.
Mark Rutan, aye.
Paul Tagliaferri, aye.
Aye. All right, Brad Blanchett, aye. All right. So noted.
I move to adjourn.
Second.
All right, Fran moved to adjourn, and I'm gonna give Dick the second. Mark thirds.
It's always next month.
All right, all those in favor to adjourn?
Fran, aye.
Dick Rand, aye.
Mark, aye.
Paul, aye.
All right. Brad as well.
Thanks a lot, David.
Unanimous. Yeah, thanks for your work, David. Appreciate it.
My pleasure.
See you guys next month.
All right, good night.